If a Supreme Court justice cuts off a member of Congress mid-sentence, who's really putting whom on trial? Imagine the scene: the Supreme Court chamber, where every word carries constitutional weight. All eyes are on Congresswoman Jasmine Crockett, a rising civil rights attorney turned lawmaker, standing alone before 9 justices. She's prepared to testify on voting rights, an issue that could reshape America. She begins, voice steady, remarks honed over months. 30 seconds. That's all she gets before one of the court's most conservative members, Brett Kavanaugh, abruptly raises a hand and stops her. "Congresswoman, I need to stop you right there. What you're saying is entirely wrong." Kavanaugh's tone is cool as he presses her grasp of constitutional law. For a moment, Congresswoman Crockett stands there, staring down what looks like a near-certain public defeat. Then, something extraordinary happens. Instead of folding, she squares her shoulders, takes a measured breath, and delivers a response, precise down to the statutory clause, impossible to dismiss, turning Kavanaugh's own words back on him. In this video, we break it all down. How did Crockett do it? What kept her so composed, and why did this clash reset the battle over voting rights? If you want more stories like this, where knowledge and composure stand toe-to-toe with concentrated power, consider subscribing and joining our community at Jasmine Crockett File. We bring you political moments that don't just shock, but inspire. Jasmine Crockett wasn't always in the national spotlight. Growing up in St. Louis, Missouri, she was raised by parents who emphasized education and civic responsibility. Her father, a Vietnam veteran who later became a postal worker, and her mother, a public school teacher, instilled in her a deep respect for public service and the Constitution. After graduating from Rhodes College with honors, she earned her law degree from the University of Houston. Before entering politics, Crockett built her reputation as a civil rights attorney, defending voting rights cases and representing those who couldn't afford legal representation. Her colleagues described her as meticulous, extraordinarily prepared, and unflappable under pressure, qualities that would serve her well in the confrontation to come. After serving in the Texas House of Representatives, where she gained attention for her passionate defense of voting rights during a contentious legislative session, Crockett was elected to Congress. Though relatively new to Washington, she quickly earned assignments to key committees, including Judiciary, where her legal background proved valuable. On the other side of this confrontation stood Justice Brett Kavanaugh. His path to the Supreme Court had been contentious from the start. Nominated by President Trump in 2018, his confirmation hearings became one of the most watched political events in recent history, marked by allegations of past misconduct and heated partisan debate. Though confirmed by the Senate, the process left deep divisions, with many Americans holding strong opinions about his temperament and judicial philosophy. On the bench, Kavanaugh had generally maintained a conservative voting record, particularly on cases involving voting rights and executive power. Legal observers noted that while he often sided with a conservative majority, he occasionally surprised analysts with more moderate positions. The case that brought these two figures into direct confrontation concerned a controversial voting law from Georgia. The law, passed in the wake of the 2020 election, implemented new ID requirements, limited drop boxes, and changed early voting procedures. Supporters called it necessary for election security. Critics argued it disproportionately affected minority voters. As the case made its way through lower courts, it became increasingly clear that the Supreme Court would likely have the final say. When oral arguments were scheduled, Congresswoman Crockett, given her background in voting rights law and her position on the House Judiciary Committee, was invited to provide testimony as an expert witness. The stage was set for a momentous hearing. Political analysts predicted a respectful but rigorous examination of constitutional principles. What no one anticipated was the unusual and confrontational interruption that would occur, or the response that would follow. The day before the hearing, Crockett was seen leaving her office late, carrying thick binders of research. A staff member later revealed she had stayed up until 2 a.m., reviewing historical voting rights cases, statistical analyses, and the personal histories of each justice she would face. She wanted to be ready for anything. The aide said it was like watching someone prepare for both the bar exam and a championship debate simultaneously. Meanwhile, at the Supreme Court, clerks reported that Justice Kavanaugh had been particularly focused on this case, requesting additional briefings and historical analyses. Something about the Georgia law seemed to touch on constitutional questions he found particularly compelling. As cameras were being positioned in the courtroom on the morning of the hearing, neither Crockett nor Kavanaugh could have predicted how their exchange would captivate the nation in just a few hours' time. The night before, Crockett had called her parents. "Mom," she said, "I feel like everything in my career has prepared me for tomorrow." Her mother replied with words that would prove prophetic. "Remember, Jasmine, when speaking truth to power, composure is your greatest weapon." The Supreme Court chamber hummed with tension as the session began. The Georgia voting rights case was third on the docket, and anticipation built with each preliminary matter the court addressed. Journalists tapped notes on their laptops, while law clerks whispered among themselves about the potential constitutional implications of the day's arguments. When the Chief Justice finally announced, "We'll now hear testimony in the matter of Thompson v. Georgia Election Board," a subtle shift occurred in the room. Justices sat up straighter, pages of notes were shuffled, reporters leaned forward slightly in the press gallery. Congresswoman Crockett was the second witness called. As she approached the podium, she exuded quiet confidence. Placing her notes carefully before her, she began with a traditional acknowledgement of the court's authority and her gratitude for being permitted to speak on such a consequential matter. "Mr. Chief Justice, and may it please the court," she began, her voice clear and measured. "The right to vote has been described by this very court as preservative of all rights. Today, I will demonstrate why Georgia's Senate Bill 202 fundamentally undermines that right for thousands of citizens." She continued with a methodical explanation of the law's provisions, citing specific passages and their practical effects. The justices listened attentively, with several taking notes. Justice Sotomayor nodded at certain points, while Justice Thomas remained characteristically inscrutable. Approximately 3 minutes into her testimony, Crockett began presenting statistical evidence showing disparate impacts on minority communities. "When we examine the data from counties with majority-minority populations, we see wait times increasing by an average of 84 minutes, while in predominantly white counties." That's when it happened. Justice Kavanaugh, who had been growing visibly restless, suddenly raised his hand and leaned toward his microphone. The interruption was jarring, not just for its timing, but for its sharp tone. "Congresswoman, I need to stop you right there," he said firmly. The room seemed to collectively hold its breath. Supreme Court protocol typically allows witnesses to complete their prepared remarks before justices begin questioning. Your entire premise appears to be built on a fundamental misunderstanding of both constitutional law and the factual record," Kavanaugh continued, his voice rising slightly. "I've reviewed the same data you are citing, and it simply doesn't support your conclusion about disparate impact." Crockett stood perfectly still, her expression neutral despite the unexpected challenge. Kavanaugh wasn't finished. "Furthermore, you're suggesting that voter ID requirements are inherently discriminatory, which contradicts this court's previous findings in Crawford v. Marion County. Are you asking us to overturn established precedent based on what appears to be selectively chosen statistics?" The question hung in the air. Several journalists later described the moment as a public ambush. Justice Kagan glanced at Kavanaugh with visible concern, while Justice Barrett shifted uncomfortably in her seat. For many witnesses, this moment would have been devastating. Legal experts interviewed later said they'd seen seasoned attorneys crumble under far less intense scrutiny from the bench. The combination of Kavanaugh's dismissive tone, the public setting, and the constitutional importance of the case created what one observer called a perfect storm of pressure. Crockett paused, her hands steady on the edges of the podium. The chamber remained silent, waiting for her response. Some observers thought they detected a slight smile crossing Justice Thomas's usually stoic face, perhaps anticipating a difficult moment for the witness. In the press gallery, reporters prepared to document what many assumed would be an uncomfortable retreat or an emotional response. Congressional witnesses historically struggled when directly challenged by justices, particularly on technical legal matters. What happened next, however, would become the defining moment of the hearing. Congresswoman Crockett took a slow, deliberate breath. She glanced briefly at her notes, but then looked up, meeting Justice Kavanaugh's gaze directly. The cameras caught this moment perfectly. The Congresswoman composed and focused, preparing to address one of the most powerful judicial figures in the country after a challenging interruption. "Justice Kavanaugh, I appreciate your question," she began, her voice steady and respectful but unwavering. "However, I believe there may be a misunderstanding about the evidence I'm presenting today. Instead of becoming defensive or flustered, Crockett methodically opened a leather portfolio that contained documents she hadn't yet referenced. This simple, unhurried action communicated a level of preparation that caught the attention of everyone present. You referenced Crawford v. Marion County, and you're absolutely correct that this court upheld Indiana's voter ID law in that case, she acknowledged. However, if I may direct the court's attention to Justice Souter's dissent in that very case, which highlighted a critical distinction that applies directly to the Georgia statute before us today. Crockett then pulled out a document and continued. Justice Souter noted, and I quote, "The law imposes an unreasonable and irrelevant burden on voters who are poor and old, disabled, or homebound." What distinguishes the Georgia law from the Indiana statute is precisely the combination of restrictions that compound upon one another. Justice Kavanaugh's expression shifted slightly. He hadn't expected such a specific and technically precise response, but Crockett was just warming up. Furthermore, she continued, "I'd like to address your concern about the statistical evidence." She produced a series of graphs and data tables that her team had prepared. These findings weren't selectively chosen, Your Honor. They come directly from Georgia's own election board data, analyzed by statisticians from 3 different universities using standard methodologies that control for county size, historical turnout, and demographic variables. She passed the documents to the court clerk to distribute to the justices. You'll note on page 4 that, when controlling for all other factors, the implementation of these specific provisions correlates with a 31% decrease in voter participation in majority-minority districts, compared to a 4% decrease in other districts. This differential impact exceeds the threshold this court established in Thornburg v. Gingles as being legally significant. The reference to this specific precedent, delivered without hesitation, raised eyebrows across the bench. Justice Sotomayor leaned forward with interest, while Justice Kagan began examining the data with newfound attention. Crockett then pivoted to address the constitutional principles at stake. The 14th and 15th Amendments, as this court has repeatedly affirmed, prohibit not just explicitly discriminatory voting practices, but also those that result in the denial or abridgment of the right to vote on account of race or color. In South Carolina v. Katzenbach, this court recognized Congress's broad power to enforce these amendments through appropriate legislation. Then came the moment that would later be described by legal scholars as the perfect constitutional checkmate. Justice Kavanaugh, in your own concurring opinion in Brnovich v. Irv, Democratic National Committee just 2 years ago, you wrote, and I quote, "The dissent is correct that the text of the VRA covers laws that have a disparate impact on minority groups' voting opportunities." You further noted that while such impact alone isn't sufficient to prove a violation, when combined with evidence of historical patterns and the absence of legitimate state interest, it creates a compelling case for judicial intervention. The chamber went completely silent. Kavanaugh had been confronted with his own words, delivered with precision and without a hint of antagonism. Crockett wasn't attacking him personally. She was engaging with his judicial philosophy on its own terms. It was a masterful approach that respected the institution while firmly standing her ground. Justice Kavanaugh, to his credit, appeared to recognize the scholarly weight of her response. He adjusted his posture and nodded slightly, a gesture that many observers interpreted as reluctant respect. "Congresswoman," he said, his tone noticeably more measured than before. "You've clearly studied this issue in depth. Let me ask you a different question. Doesn't Georgia have a legitimate interest in ensuring election security without missing a beat?" Crockett responded, "Absolutely. Your Honor, every state has not just an interest but a duty to maintain election integrity. The constitutional question before this court isn't whether Georgia can implement security measures, but whether these specific measures impose burdens that fall disproportionately on certain communities without sufficient justification." She pulled out another document. If I may, the state's own election commission found no significant instances of the type of fraud these measures purportedly address. Between 2018 and 2020, Georgia conducted over 65 investigations into alleged voting irregularities. None resulted in findings that would have been prevented by the restrictions in Senate Bill 202. What happened next surprised everyone. Justice Barrett, who had been silently observing the exchange, "About masked, Congresswoman Crockett, Are there alternative security measures that would accomplish Georgia's stated goals without the disparate impact you're describing? It was a lifeline of sorts, an opportunity to move beyond the confrontation with Kavanaugh and address the broader issues. Crockett's response demonstrated that she had considered every angle of the case. Justice Barrett, thank you for that important question. Yes, there are numerous evidence-based approaches that have been successfully implemented in states like Kentucky, Utah, and Michigan that maintain or even enhance security while expanding access. She proceeded to outline specific alternatives, citing research studies, implementation costs, and effectiveness metrics for each one. The level of detail was remarkable, showing that she hadn't simply come to criticize, but to provide constructive solutions. By this point, the energy in the chamber had transformed. What began as a tense confrontation had evolved into one of the most substantive discussions of voting rights law the court had witnessed in recent sessions. Even justices who might disagree with Crockett's conclusions appeared engaged with her arguments. Justice Kavanaugh, who had initiated the exchange with skepticism, now listened attentively. When Crockett finished her response to Justice Barrett, he asked a follow-up question that was notably more technical and less confrontational. Your analysis of the data is compelling, he acknowledged, but how do you reconcile it with this court's general reluctance to interfere with state election procedures, as emphasized in Shelby County v. Holder? Crockett nodded respectfully. Recognizing the legitimate judicial concern about federalism, her response demonstrated an understanding of the court's institutional role and history. Justice Kavanaugh, Shelby County indeed emphasized the importance of state autonomy in managing their elections. However, Chief Justice Roberts' majority opinion in that very case also affirmed that the 15th Amendment is not designed to punish for the past. Its purpose is to ensure a better future. The data before you today isn't about relitigating history, but addressing present-day effects that threaten that better future. As she concluded her response, a rare murmur of appreciation rippled through the typically stoic Supreme Court chamber. Law clerks exchanged glances. Veteran court reporters would later describe it as one of the most effective recoveries from a judicial challenge they had ever witnessed. The Chief Justice, recognizing the significance of the exchange, extended Crockett's time by 5 minutes, a rare courtesy that signaled the value the court placed on her testimony. By the time Congresswoman Crockett concluded her remarks, she had transformed what began as a potentially humiliating interruption into a showcase of constitutional expertise and dignified advocacy. The visual contrast between the initial interruption and the respectful attention she now commanded from the entire bench told a story more powerful than words. As she gathered her documents and stepped away from the podium, Justice Sotomayor nodded slightly in her direction, a subtle but meaningful acknowledgement from one legal mind to another. What no one in the chamber could know at that moment was how quickly this exchange would spread beyond the court's walls, captivating Americans from all walks of life and political persuasions. The Supreme Court session concluded at 3:42 p.m. Eastern Time by 4:15 p.m. Clips of the exchange between Justice Kavanaugh and Congresswoman Crockett had already begun circulating on social media. A C-SPAN video titled "Congresswoman Educates Supreme Court on Voting Rights" accumulated 100,000 views within the first hour. What made the response truly remarkable wasn't just its reach, but the unusual bipartisan admiration it generated. In an era of intense political polarization, Americans across the political spectrum found something to respect in Crockett's composed, substantive response. Conservative legal commentator William Jacobson wrote on his widely read blog, "While I may disagree with her conclusions, Congresswoman Crockett's command of constitutional precedent and respectful but unwavering demeanor represents the best tradition of legal advocacy. This is how constitutional debates should unfold." Meanwhile, progressive outlets highlighted both the substance and symbolism of the moment. In less than 10 minutes, Crockett provided a masterclass in how to stand your ground with dignity and facts, wrote political analyst Maria Henderson, for women, people of color, and anyone who has faced being dismissed or interrupted in professional settings. This was a watershed moment. By the following morning, the exchange had transcended political news to become a cultural touchpoint. Morning shows played clips of the interaction, with hosts and guests analyzing both the legal substance and the human drama of the confrontation. What we witnessed was the power of preparation meeting opportunity. explained former Supreme Court Clerk Jason Mitchell on Good Morning America. Justice Kavanaugh raised legitimate judicial concerns, but Congresswoman Crockett had clearly anticipated every possible challenge to her position. That level of preparation is exceedingly rare, even among experienced Supreme Court advocates. Social media platforms reflected the public's fascination. The hashtag #NoshComposedCrockett began trending nationally, with users sharing their own stories of maintaining dignity under pressure. Law schools reported that professors were already incorporating the exchange into their curriculum as an example of effective oral advocacy. Perhaps most tellingly, a diverse range of professional organizations, from the American Bar Association to corporate leadership groups, requested permission to use the clip in training sessions about communication under pressure and responding to challenges with grace. Jasmine Crockett kept her focus where it had been all along, on the law and the voters it protects. She declined to personalize the viral moment, limiting her public remarks to the substance of the case. When a reporter pressed her on how she stayed so composed, she answered evenly. The constitutional rights of American voters were at stake. That's far more important than any personal feelings in the moment. 3 days later, an unexpected coda. At a previously scheduled talk at Georgetown Law, Justice Brett Kavanaugh addressed the exchange without prompting. "I've been thinking about the hearing earlier this week," he told a room of students. "Our legal system functions best when advocates can forcefully yet respectfully challenge each other's thinking." Congresswoman Crockett's testimony reminded all of us on the bench of the importance of engaging with the strongest version of arguments, especially on issues as fundamental as voting rights. He did not endorse her position. He did, however, publicly acknowledge her effectiveness, an act many read as professional respect that cut across politics. From there, the conversation widened. Court watchers began to ask whether the exchange might shape the ultimate decision in the Georgia case, especially with the court's moderates. What Crockett had offered, analysts noted, wasn't theater. It was advocacy calibrated to the court's own tests. By engaging Justice Kavanaugh's stated philosophy and written opinions directly, she made it harder to wave away her claims, observed constitutional scholar Diane Reynolds. The point landed. If you argue before the court, argue in the court's language. Outside the marble walls, the debate shifted from spectacle to substance. Editorial boards held up the moment as a model for public discourse. Facts first, dignity intact. In an era when shouting has replaced debating, when sound bites have replaced sound arguments, the exchange between Justice Kavanaugh and Congresswoman Crockett offers a different path forward, wrote The Washington Post in letters to the editor and comment threads. A similar sentiment surfaced again and again, especially among listeners who had watched political conversation erode over decades. "I don't care which side you're on," wrote Thomas Williams, 58, from Georgia. "What I saw was someone who did their homework, knew their facts, and answered with dignity instead of outrage. We need more of that." 6 weeks after the hearing, the ruling arrived. In a nuanced 6-3 decision, the Supreme Court struck down several provisions of Georgia's law while leaving others in place. Legal analysts immediately noted that the majority opinion, authored by Chief Justice John Roberts, cited specific evidence Crockett had laid out in her testimony. It wasn't a total victory or a total defeat. It was the kind of mixed, carefully reasoned opinion that has long defined the court at its most cautious. Yet it moved the line on what states may and may not do when security collides with access. For Crockett, the consequences were immediate and practical. Law schools invited her to speak on constitutional advocacy under pressure. The American Bar Association recognized her with its Distinguished Public Service Award. Her years as a civil rights attorney, now joined to a high-profile public performance, positioned her as a durable voice in the national debate over voting rights. The deeper impact, though, showed up in inboxes and admissions portals. Law school clinics reported a bump in applications, especially from young women and students of color who described the exchange as a turning point. Professors added the moment to syllabi on appellate practice and the Voting Rights Act, not as a partisan rally, but as a case study in matching preparation to principle. What endured was less the clash than the craft. The lesson was old and newly urgent. Prepare thoroughly, argue respectfully, and keep your composure when the stakes are highest. In a political era enamored of volume, the exchange suggested another way, one where conviction is measured not by decibels but by discipline. Months later, Speaking at her alma mater, Crockett distilled the ethic. When we prepare thoroughly, speak truthfully, and maintain our dignity, we honor not just ourselves, but the democratic institutions we serve. The day at the court, she emphasized, wasn't about winning an argument. It was about ensuring that every American's right to vote received the serious consideration it deserves. That is why the story continues to travel, because it shows what can happen when knowledge meets composure, when preparation meets opportunity, and when respect for institutions keeps pace with the courage to challenge them. Share your thoughts below. I genuinely want to hear from you. If this story resonated with you, please like, share, subscribe to Jasmine Crockett File, and tap the bell so you won't miss the next chapter. Don't miss the featured video now on your screen. It's a story I'm especially proud of. Thank you for your continued support, and I'll see you next time.